Hi, I'm Pat Pou. I'm a partner at Lazega Johanson and I manage the litigation team and handle litigation matters for our clients. A lot of what I do relates to enforcement of covenants in community associations. One thing that comes up again and again is failure by a board of directors to timely enforce the covenants. When an owner violates the association's covenants, it is important for the association to act quickly to preserve its rights and maintain the community standards. If the association sits on its rights and does not act timely to address violations of a particular covenant, it may be deemed to have waived or abandoned the right to enforce that covenant. Further, if the association does not enforce the covenants consistently and uniformly as to all members of the association, an owner might raise a defense of arbitrary or selective enforcement and then avoid compliance. These are some of several often raised defenses when associations seek to enforce the rules. So what should the board consider and do when faced with such a violation of the covenants? Basic answer: enforce the rules strictly in accordance with the declaration and do it consistently, uniformly, and timely. The first two seem simple enough, and you can't be arbitrary about enforcing the rules, and you must treat everyone the same. There are certainly several pitfalls here, which can be ample topic for another discussion. For this discussion, we're looking at the third point, timeliness. Here are some considerations to be prepared. Know your documents. Effective enforcement of covenants requires knowing the governing legal documents for the community. These documents should specify the enforcement powers of the association and the procedures to be followed. Can you impose fines? Can you, the association, fix the violation yourself? This is called self-help. And if so, how? What notice is required? The answers to these questions are or should be in your governing documents. Act promptly. Once a violation is detected or brought to the attention of the board of directors, address it quickly. Failure to act promptly may result in a valid defense to the enforcement of the violation. Violations addressed quickly are often easier to resolve. If the proper notice and demand letter don't work, the association will want to consider filing an enforcement lawsuit to get an order from the court requiring the owner to fix the violation. For example, a court order might be required to make the owner paint their house or take down that unapproved basketball goal, fence, or garage. The association must act timely in order to pursue, preserve, and enforce its rights. This means the lawsuit must be filed before the expiration of the statute of limitations. What does that mean? A statute of limitations prescribes a time limit for bringing a certain legal action. Once the statute of limitations expires on a claim, you can no longer bring a lawsuit on that claim to stop the violation. In Georgia, the statute of limitations for a covenant enforcement action is generally 2 years. This means an association has 2 years from the date of the violation to file a lawsuit. If you don't, then you can't use the court to make the owner stop the violation. Surprisingly, the law in Georgia regarding this statute of limitations for covenant violations is not as straightforward as one might think or hope. In fact, it has been an evolving area of the law in recent years, with multiple decisions in the Court of Appeals. There remains legal debate about when the claim may be brought, so the association should avoid this debate and pursue enforcement promptly.